What do you do with the fact that the brokers, I think the amicus brief of the Transportation Intermediaries Association, particularly pages 20 to 24, really go in detail of if tort liability extends to them, how are they going to assess and evaluate the safety of drivers in a particular trucking company? How are they going to figure out, do they have an alcohol drug issue? How are they going to figure out English proficiency, which of course is a critical issue at the current moment that's being discussed? How are they going to do this is the real concern that's raised in that brief and by respondents that I think is something you need to respond to.
Sure, I'll try to respond to it, and I think it may be much more straightforward than you think in many cases. I mean, ultimately, like the legal answer is it's the know or should have known standard. But
usually when you say that, sorry to interrupt, there's some way for the tortfeasor to protect themselves, and what they're saying here is in the real world of how brokers operate, it's very difficult.
So I think it's going to be pretty easy for them to protect themselves by hiring quality carriers.
And that's going to favor so this whole thing's going to really favor the large established carriers over the smaller carriers because they're going to default to that to protect themselves, I think, which is fine, but I just wanted the implications of your position to be understood.
Look, you can be a safe small carrier, and here's the thing, and this is where
they tend not to be as safe as the larger ones, correct?
Well, some of them tend to be very unsafe, and some of them tend to be these chameleon carriers where their safety record is terrible, and then they show back up. And the situations where there should be liability is when the broker knows, or should know, that it's a chameleon carrier. If they've just been dealing with this carrier as, Joe's Trucking, run by Joe Smith, and then all of a sudden Joe Smith shows up, and this time it's Smith Trucking, the carrier's going to know that, the broker's going to know that. And here's one of the things that sort of helped me understand all of this, which is you have a number of situations where there is a captive carrier, where that carrier does only loads for C.H. Robinson. And so in that circumstance, C.H. Robinson is going to know every bit as much as the carrier is going to know in those circumstances. Now, there are going to be other situations, like say, they can protect themselves, but they can also protect themselves by asking some questions and having some screens. I mean, this is a case where C.H. Robinson's own policy says that they don't hire carriers that have conditional safety ratings, but they did it here anyways. So, so you have cases like that where, yeah, you can worry a little bit about how they're going to protect themselves, but they already take some efforts. And when they blow their own sort of standards, or
well, they were relying on the federal government standards because the federal government regulates the trucking companies and kind of certifies them. That's probably not good enough, is what you're saying, which I'm not taking issue with that, but that's what they've been relying on in the past, right?
But the federal government regulates in a very minimal way, and the federal statute specifically says it's a minimum, not a maximum, and states are free to go above that. And, I mean, you really can't underestimate.
Again, for the carriers, that begs the question, but keep going. Yeah.
I mean, the statistics that the amicus briefs have shown is that roughly 94% of carriers have not had, a safety exam by the federal government. And the way this works is to get on the road in the first instance, you do not have to go through it's kind of less rigorous than getting your state driver's license for a car. So.
Thank you, counsel.